Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you through 3 hours of Courtlandia, but we're jumping right into the deep end of the pool. This is Judge O'Donnell.
State of Ohio versus Daniel Barber, case number 26 CR 000-364. The defendant is present in open court with their attorney, William Watson. We are set today for a sentencing hearing. We were previously here on May 8th when the defendant pled guilty to 3 counts of trafficking in cocaine, 2 of those being a felony in the 5th degree, 1 being a felony in the 4th degree, and 1 count of possession of a fentanyl-related compound, a felony in the 4th degree. Since then, a pre-sentence report and drug and alcohol assessment have been completed. The defendant has 92 days of jail time credit.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'll be brief. We're here this morning hat in hand. I know my client has a history, and more specifically, he's got a history with this particular court. Previously, he was granted community control, although, yes, he did complete that successfully. Obviously, he's gotten himself into more trouble and is in front of Your Honor again. Your Honor, my client, I don't think is an evil person. Obviously, he makes a lot of very poor choices, though. He was doing what he thought he needed to do to get by. Obviously, that's wrong. He knows it. He spent the past 3 months in county jail here, and I've talked to him, and he's told me that I think he's in his mid-30s now. And he's like, look, I don't want to do this anymore. I don't want to sit in jail. I don't want to, have to go to court. He wants to turn his life around. He has a family. He has a state. If the court were to consider a community controlled sanction, he does have a stable residence here in Lake County. He has a job lined up. He said it was a union job. My apologies to the court. I don't recall which one, but he has a job lined up. I know that it's a long shot based upon his history, but I do think Mr. Barber has some redeeming qualities, and I do believe he can do what is necessary and what is right. I'm hoping the court will consider a community control sanction with whatever restrictions the court deems necessary. Give him this opportunity, this last opportunity, to show the court that he can do what needs to be done and he's never going to come back here again. Thank you, Your Honor.
Mr. Barber, what do you want to tell me before I impose sentence?
First of all, I want to apologize to the court. I want to apologize to you, too, O'Donnell, by even coming back here for a sentencing again. I just want to start off by saying I take full responsibility in my actions. I know what I was doing.
Tell me how you take responsibility for your actions?
I know what I was doing was wrong.
Then why'd you do it?
That's what I was about to get to. I want to start by saying I started off with a job. I had a good job. I was I paid off all my fines. I got my license like you asked me to. I paid like $3,000 in fines to get my license. I got a car. I was taking care of my twins. I was taking care of my daughter. I was taking care of my household, for real. I fell into a little hardship with my job. After like 3 or 4 years, I was working my job for about 3.5 years. I fell in a lot of hardship because I slipped and fell at work, and right before they were supposed to be compensating me at work for missing work a lot by having to go to the doctor, that I got laid off. When I got laid off, it started getting a little hard for me. I started falling back in debt. I started taking out loans, all type of stuff. Like, I just kept getting more and more in debt. I ended up losing my car by getting presents and stuff for Christmas and birthdays and stuff like that. I just fell back into debt, and it just got hard for me. So I feel like that I had to come up with a way to keep my lights on. The heat for my girl put me out. All type of stuff was just going on. So that's why I take full responsibility and what I did, because I knew it was wrong, but the only way only thing I did, I feel like I should have did differently was I should have called my old probation officer, which he told me to call her if I ever got into any.
Who was that?
I think her name was Haley, Miss Haley, because I forgot the first one I had, but Haley was my second one. And she told me to call her if I ever got into any trouble or I needed some help with anything, and I forgot all about that, for real. So all I ask is that you give me one more chance on some supervision, so, because that's what really keeps me out of trouble, like me being
You're,
supervised. Huh? I ain't hear you.
You're 34 years old.
Yeah, I know.
Can't supervise you forever.
Right.
I mean, that's been tried, right? Over and over and over again since '09.
Yeah.
How long have you been dealing drugs?
Probably like 10 years.
Why were you dealing drugs if you were working as a machinist?
No, you're talking about how long this time?
Well, yeah, how long this time?
Probably like for the last year.
Okay. So you got cocaine, you got fentanyl, what else you got?
That's all.
That's all. Where were you getting it?
Off the street.
Which street, Drenick?
No,
100, East 100?
probably Cleveland.
Why are you dealing drugs if you have the ability to earn $20 an hour?
Well, it was just, it was hard for me to find another job, too, because I filled out a lot of applications, but all the calls came back. It was from Solon and Lakewood and places that was far in the wintertime, basically. It was like, and then I lost my car, so it was hard for me to get out to Solon and stuff like that. And then one of the jobs I went to in like Wickliffe, around my area.
God, I had a guy named Jared Bell who was on probation a few years back. Lived in Cleveland, had custody of his minor child. Took buses out to Solon, where he worked every day. Pain in the ass, but he did it. Got off of probation, successfully completed it. So,
I feel like I can do that. I feel
well,
like I can
you
try
should
to
have
do
done
it.
that
Yeah.
instead of dealing drugs.
Right.
Because who you selling to?
You're right.
I mean, who are you selling to?
Some guy named Mike Thompson.
Well, I know on this occasion, but you were selling to a bunch of people, right?
No, that was it.
That was it? You only sold to him?
hmm
He's the only guy you sold to. How long have you been selling to him?
I was selling to him for probably about 10 years. I knew him for like 10 years.
He's the only guy you sold to.
No, not per se.
Well, not, what does that mean? I asked you who you were selling to, and you said the only guy you sold to was this Thompson guy.
I don't know everybody. I don't know names.
Okay, how many guys you been selling to? How many people you been selling to?
Recently?
In the last 2 years.
Probably like 3 or 4.
How much money you make off of that in the last 2 years?
Not much.
Not much, but you were doing it to make money. So what else were you doing for money when you got fired from the machine job?
I was gambling. I was gambling on sports bets, which I was losing more money.
That's why gambling exists, for the house to win.
Yeah, I learned that. I stopped. I cut gambling out. I don't gamble. No, I don't gamble.
What
on
kind of
sports
drugs
bets.
you use?
I don't use drugs. I only just got my marijuana, my medical card for my shoulders, my back pains.
So was this a regular thing you did, was use the Clark gas station to do your transactions? Because 3 out of 4 were at Clark, right? Or was one at the house? I can't remember, I lost track.
No, it was mostly up at Clark Glass
So
Station.
you just walk from the house over to Clark, do
Yeah,
your
or
deal
if I-
and go home?
Yeah, if I probably was somewhere else,
Who was your supplier?
I didn't have a supplier.
Then where'd you get the drugs?
From friends on the street in Cleveland.
So you would buy a bunch from them and then sell it to whoever wanted to buy it from you?
Not per se buy it from them. I probably would just ask them for it to help me out so I can get some extra money.
So the suppliers are giving their drugs away? That doesn't seem likely to me, or believable.
I mean, I was though. I definitely.
There are a lot of
got
generous
some.
drug dealers out there?
To me, probably. I don't know. I don't think so.
This isn't your first go-around with trafficking, right?
Possessions, no.
Trafficking.
Trafficking, no.
You never had a trafficking before?
Yeah, I had one, but
In '09, you had a trafficking in Cuyahoga.
it was a dime sack of weed when I first was like 18. I sold an undercover a bag of weed.
Put on probation, violated probation. Got a number of misdemeanors until through 11, and you got an attempted burglary in 11 in Cuyahoga County.
Yeah, it was more of us receiving stolen property, but I copped out to it because my friend had passed away. So they told me if I go to CBCF, then they would expunge it, and I guess it never got expunged. But I completed the program, and they never expunged it.
What were the probation violations for when you were on probation for that?
Failure to report, I think.
Why did you fail to report?
I think it was more transportation.
Then a few more misdemeanors, 13, 14, and 15, then a drug possession, F5, and 15 in Cuyahoga. What was that all about?
I think I probably got caught with some marijuana. I can't really remember.
You were put in a CBCF on that occasion and failed to complete it. What happened there?
In CBCF, no, I completed all my CBCFs.
That's not what that case was reporting out.
I don't know what that means. I completed my CBCF.
August 25th, 2018, probation violation for failure to complete CBCF. Probation terminated.
Yeah, I don't know what that is about because I completed it.
And after that, or actually in 15, you get a drug abuse, 17 drugs, misdemeanors.
Yeah, I completed that, so I don't know.
Weapons under disability here in 20 offense, put on probation in 23. Hanging around with Okema Seeley. For some reason, I let you off early. My mistake. At the same time, you got another weapons charge in Cuyahoga.
It wasn't your mistake. I did what I was supposed to do for you. I
Well,
did.
apparently, I wasn't very perceptive if you've been dealing drugs that whole time. But, so you get off of probation. And you got your chance to start over again and you're dealing drugs again. So you don't appear to, you've been sliding through for a long time. You didn't seem all too interested in this whole process when I sent you over to probation.
When?
May 8th.
When you sent me to probation on May 8th.
Uh-huh.
I did.
Mr. Clement, how interested was he in this process of completing this report?
Yeah, certain sections he did, or explain what was going on. I asked a couple times in regards to what happened with the scenario with the dealing charges, trafficking charges. And what I got from him was I was caught stealing drugs. Didn't want to elaborate on the case. I asked him if he had to tell me the story, how he ended up with the charge, how did he end up here. That was a response that I got. And then in regards to drug and alcohol piece, I asked him if he had any drug and alcohol use, including marijuana, and he reported none to me.
I did. I said I have my marijuana card. I don't have no. I didn't.
Why don't you use other drugs?
I just don't use drugs.
I know, but why?
I mean, because I feel like you can get addicted to it.
Right, so you don't have a problem getting other people addicted to it. You just don't want it because you know it's a negative, but you don't have any problem selling fentanyl to other people, right? Or cocaine or whatever else is in it. I'm sure that you verify whenever you got cocaine, were given cocaine from suppliers, that there was nothing other than cocaine in it, right?
Yes.
No. How would you verify that? You have some lab in your basement that you were testing this stuff?
No.
You're peddling whatever you're peddling, you have no idea what it is, and some of it's fentanyl.
Right.
And you know that you're hooking people, but you don't care about that. You just want to make a little bit of money, and you were, by your own admission, just a little bit of money, not a lot of money.
You're right. I feel bad about it though.
Well, you should feel bad about it. Anything else you want to tell me?
I'm kind of nervous, man, because I ain't got nothing support here today, so.
Well, where's your support?
That's about it. They was gonna come here, but our court date got pushed up to today. It was yesterday. My court date was tomorrow, so my grandmother, my kids, and my girl wasn't able to show up today. Well, I couldn't contact them because the phone was off early in the morning. But they was gonna be here tomorrow, and I was gonna show you how I was taking care of my daughter in boxing classes, show you some of the videos that she was doing. And you was gonna be able to meet my twins.
What, you got a problem if your twins are 18, right?
19.
19. You got a problem if somebody's out there dealing drugs to your fentanyl or cocaine to your twins?
Absolutely.
Why? Why can you do it and somebody else can't do it?
I mean, because I wouldn't want my kids to be hooked on drugs either.
Okay, why do you have no problem hooking other people on drugs then? Those are somebody else's kids, right? Somebody else's father, brother,
I do have a problem with it.
son.
I do have
Then
a
why did you
problem
do
with
it? You've been doing it for 10 years. And you've been doing pretty Leaving alone the 10-year thing, you've been doing pretty consistent for a year, because they know where to find you. So you don't have a problem getting somebody else hooked on it. You don't want your kids hooked on it, or you hooked on it. Because it's out of sight, out of mind. Here's your thing, give me my money, on to the next thing, right?
Pretty much.
All right, have a seat, Mr. Knopf.
Thank you, Your Honor. The state's recommending that the defendant serve a prison term. I know you went over his history before, but he does have 5 prior felonies, trafficking offenses in 2009 with 2 probation violations, attempted burglary in F4 in 2011 with 2 probation violations, drug possession F5 2015 with 2 probation violations, weapons and disability in F3 in 2020 with 1 probation violation, and another attempted weapons and disability in 2023. So the defendant has not responded favorably to previously imposed community control sanctions, though I will say he was terminated once successfully from probation. He has eluded prison for all those felonies. He does have multiple misdemeanor charges on top of those felonies. And I think it does make it worse that the defendant does not even have a drug problem himself. He has been using the marijuana, but again, he's selling this to random members of our society. So I don't see anything that makes this less serious. There was an aggravating factor for being close to a school in one of the counts. So again, the state's recommending a prison term.
What school is close to you, where you live?
Children's learning, I think.
All right, I reviewed the pre-sentence report, the drug and alcohol evaluation. I went back and reviewed the prior pre-sentence report from the 23 case. And I have considered all the provisions in 29, 29, 11, 12, 13, and 14. And I've listened to Mr. Barber, listened to counsel. And as I've spent some time here going through Mr. Barber's record, which goes back to the first trafficking offense in 2009. And as Mr. Knopf indicated, a total of 5 felonies. And you've always been given the opportunity to get your act together, and you haven't taken advantage of it by virtue of the fact that you're here again for peddling cocaine, fentanyl, and who knows what else to other people. You tell me you don't do those kind of drugs because you don't want to get hooked, that you would take offense to people selling it to your 19-year-olds because you don't want them getting hooked, but you don't care if anybody else gets hooked because you're making money off it. So you are not amenable to community control. On count 1, I'm going to sentence you to 12 months in prison. Count 2, 16 months in prison. Count 3, 12 months in prison. Count 6, 17 months in prison. You get credit for 93 days served. Counts 2 and 6 will be consecutive to each other. Counts 1 and 3 will be concurrent to each other and concurrent to counts 2 and 6. So it's a total of 33 months with credit for 93 days. And the costs are assessed when you get out. You may be on post-release control for up to 2 years under the parole authority with conditions. If you violate, parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control. Consecutive service is necessary to protect the public from future crime by you and to give you the appropriate punishment, and they are not disproportionate to the seriousness of your offenses and and the danger you pose to the public, and your history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by you. The remaining charges are dismissed. Anything subject to forfeiture is forfeited to the state. Anything else, Mr. Knopf?
No, Your Honor. Thank you.
Mr. Watson?
Nothing further, Your Honor.
Good morning once again, everybody. Happy Tuesday, TCF Live. My name is Dan. To those of you who are new here, welcome. It's good to have you. Tim gifted 5 memberships during that. Thank you, Tim. Landed right on our new friend Tammy, so that was cool. The odds are never in favor of that, but it happened. We love when that happens. So Wahoo asked in the comments, can he be redeemed? And several of you have shared your opinion. I'll give you mine. The man of faith that I am, I would love to say yes, absolutely, he can be redeemed. But I also know that redemption requires participation. And personally, I'm not convinced that he is anywhere near ready for participation and might not ever be. Therefore, I will say, unfortunately, I don't see it. Hope I'm wrong, though. I really do. Let's go up to Michigan. Say good morning to our good friend, Judge Middleton.
With Marie Shoemaker. I can't recognize you because you're wearing camouflage, so it makes it hard for me to see you in. You got a ticket way back in July of 2025 for driving out a valid operator's license and having no cycle endorsement. Those are kind of the same charge. Charged under 3 ordinance. Take a look at your ticket. Yes, thank you. There we go, there's Mr. George. Mr. Shoemaker, let's take a look at your ticket. You got this ticket on August 30th at 4 o'clock in the afternoon at Gleason Road and 131 in Fabius Township. Why does this show as an OT? All right, that was on August 5th. We've got several different citations here. I guess that's my issue. On August 5th, you got charged with driving without a license, leaving the scene of a property damage accident, and driving without due care and caution. Driver crashed vehicle and left the scene. The most serious charge is, I guess, no license ever applied as a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Leaving the scene of a property damage accident is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Driving without due care and caution is a civil infraction, and that may have already been defaulted. Yes, it is. You owe that ticket. You didn't answer the thing and you got defaulted on the due care and caution. Then you got another citation in July of 25 for driving without a valid cycle endorsement. Didn't show up for your arraignment. We issued a warrant for your arrest. You got arrested in May. You came up to the court, actually. So you got 2 tickets. You got one on July 21st. And that one, they allege you were driving a vehicle without ever having a license, and that was in Three Rivers on July 21st of 2025. You got a ticket that said you were supposed to show up on August 5th. Let me look at this. Yeah, it said you were supposed to show up on August 5th, 2024. Well, it'd been hard to do. Anyway, you didn't show up on August 5th on that ticket. And the other ticket, you got a citation, I think it said you were supposed to show up on a different day. You were supposed to show up on August 4th, 2025. You didn't show up on the 4th or the 5th. And a bench warrant issued for your arrest. I think we did a show cause. You didn't show up for that. Then you posted bond here at the jail on both of these tickets. You also got defaulted on that due care and caution civil infraction. When you don't show up on a civil infraction, they enter a default. So this is a little complicated. You got two separate cases, two separate dates that you failed to appear on. You did show up and post a bond in each case. Do you have a license now? No? How'd you get here?
My mom,
Where's she?
out in the car.
Oh, she's missing all this fun. Do you still live in Decatur?
No,
Where do you live now?
with my boyfriend's mom,
Which is where?
White
What-
Pigeon.
It just says you've never applied for a license. Did you ever have a license in another state?
No, I have seizures, so I have to wait until I go 6 months without having them.
You have a medical condition that prevents the license? We had a man years ago who had seizures and he kept driving. We kept trying to stop him. And he had a seizure in the drive-thru at McDonald's and he ran over somebody and killed him. And he's charged with vehicular homicide. Went out in the field one night and laid down and froze to death. Anyway, there's issues going on here. Jeanette, I think the safest thing to do maybe is to get an attorney in all of these.
Yes, I was going to suggest that, Your Honor.
All right, my recommendation and the public defender's recommendation is you should plead not guilty and I get an attorney to help you with this. Do you have an objection to that?
What was that?
My recommendation is that you plead not guilty and I get a lawyer to help you with these charges. One, I would tell you to try to get your license, but it sounds like that's going to be harder to do. So do you wish to plead not guilty or do you wish to plead guilty to these charges?
Not guilty.
All right, I'm going to appoint an attorney. Set attorney pretrial for 6/26/26 at 8 for all counts. As a default in 25907. You know, when you don't show up, now, I don't know why you didn't show up on the 4th or 5th of August of last year, but in May, you came in this year to try to get these cases back on track. And that's a good thing. What do you do in White Pigeon? Do you work anywhere?
Yeah, I'm a assistant manager at Dollar General.
At where?
Dollar General.
Okay. Right in White Pigeon?
Mhm.
All right, I'm gonna have the court officer take you out. We'll get a court appointed attorney for you on all these. Maybe we can figure out what the deal is, but you gotta stop driving. I don't want you to freeze to death in the middle of the field one night. All right, you're good to go. Billy Joe Curtis. Good morning.
Good morning.
Are you Billy Joe Curtis?
Yes.
Do you know who Sadie Sink is?
Huh?
Do you know who Sadie Sink is?
I don't think so.
All right. Miss Curtis, you got a ticket for violation of an instructional permit. And no valid license plates.
Your Honor,
Yes,
I was thinking maybe that was a double dip on that perhaps.
yes.
I was going to advise her to plead not guilty and get an attorney to straighten that out.
All right, well, let's talk about it here for a minute. No valid license is one charge. You're charged with violation of instructional permit, which generally has to do with driving a car without having an adult driver in the car. Let's take a look at your ticket. Mr. George was here. We could use his help.
Yeah, just stepped out, I think. There may be an
Unregistered vehicle / no trailer plate. You were driving at 12:22 in the morning at River Drive and Wood Street. Drove without license, driver on permit, no proof of registration. Your license is valid now? You took the test and you got done with your permit?
I took the permit test, but I haven't taken the driver's test yet.
Well, it says here you're valid. Oh, temporary permit. Issued April 3rd, expired September 30th. Are you set to take the driver's test?
I'm supposed to go today at 1 o'clock to take the test.
What about the plate? Did you get the plate straightened out?
No, the car's still in impound.
Oh, the car got impounded?
Yeah.
Whose car was it?
It was my boyfriend's dad's car.
This was on May 25th. That's very expensive. So they're probably gonna just lose the car?
Yeah.
Ms. Jackson, my suggestion is we just adjourn this. I don't really want to appoint an attorney on a case where I'm not gonna. ever
But
send it
that's
to
fine,
jail.
maybe, maybe Mr. George has an offer that might work for her this morning. I don't.
He might,
He
I'm
stepped
guessing what
downstairs.
he'll do is adjourn it for her to go
Okay.
get past the driver test.
Right, that's true. That's
So I'm gonna reset this. For a Tuesday that I don't have pre-exam conferences. Today's the 9th. I'm gonna set it for an even number Tuesday. Give you a chance to take your test. And ace it. I'm gonna set this for June 30th. If I had a clerk in here, I'd have them give you this. What do you do, Miss Curtis?
What?
Do you work somewhere?
No, I'm currently pregnant.
Okay. I tell everybody at new judge school, don't ask anybody if they're pregnant. We'll set this for June 30th. What's your due date?
December 9th.
All right, well, you got time to take care of this business. Bring proof of license. If you get charged with this and convicted, you're gonna not be able to get your license. It's gonna set you back and you're gonna have to start over again. If you come in with your license, Mr. George is likely to give you some consideration for a charge that won't affect your ability to get your driving privileges. So what I'd like you to do, Mr. George, this young woman, Billy Joe Curtis, got charged with driving with an invalid plate and driving in violation of a permit. And she's taking her driver's test today. Okay. So I've adjourned it for her to come back with her license, and then I'm sure you'll give some consideration.
Yes, sir. That works for me.
All right. All right, I'll see you on June 30th at 8:30.
Okay.
You can bring your license. I want you to get an A on your test.
Alrighty, friends. Good morning once again. TCF Live on this fine Tuesday. Looking outside the window of the bunker, the sun is shining and the birds are on fire. A typical day here in the desert. Hi, Ellie. I want to do something a little different. I'm going to put us in the Wayback Machine, and we're going to go back to yesterday. So in Bay County, Florida, they had a swearing in for a new judge, Alicia Carruthers. And then she immediately went to work and did an hour-and-a-half first appearance docket. I'm not going to show the whole hour and a half, but I'm curious about this new judge. So let's take a look at her. We'll watch her for a little bit, not the whole docket, though. This is Bay County, Judge Carruthers.
Yeah. Okay. Good afternoon, Ms. Harper. You're here for your first appearance. I understand that the jail has informed you of your rights, but in the event that you need to be reminded, you have the right to remain silent, right to counsel, and right to communicate with counsel, family, or friends for help. You are charged with, you're charged with a misdemeanor, driving while suspended, license suspended or revoked, and that what level misdemeanor could change based on any previous history. I've reviewed the complaint ticket and find that there's probable cause. I have reviewed your criminal indigent application, and it says here that you are seeking a court-appointed attorney. Is that correct? Yeah. Okay. And it states here that you have 0 dependents and 0 take-home income. Is that accurate?
I have income, but I just don't have a job.
Okay, so you are not currently working.
No,
When was the last time you were working?
I never had a job.
Okay. All right. Based on that information, I will find that you are entitled to receive the services of the public defender. Mr. Floyd here is on the screen. Okay. Is there any history on Ms. Harper?
Yes, DUI 24.
And any FTAs?
No, ma'am.
Ms. Harper, I see here that your driver's license says West Palm Beach. Are you going to be able to make it back to Bay County for your court date?
Yes.
Okay. I'm going to set $1,000 bond on this case, and your next court date is June 10th of 2026. Okay.
Okay. Step to your right to the C. When the green light comes on, sign. Next. That's not her. That's not the right one. Step out real quick. It's the lockdown. Yeah. We got it. Right, yes, ma'am. Face the TV and state your name.
Nicole Winehandle?
Ms. Winehandle, did I hear you correctly? Okay.
Yes, ma'am.
All right. Good afternoon, Ms. Winehandle. You're here for your first appearance. I understand the jail has informed you of your rights, but in the event you need to be reminded, you have the right to remain silent, the right to counsel, and right to communicate with counsel, family, or friends for help. I have 3 charges in front of me. Failure to appear, a second-degree misdemeanor of disturbing the peace or breach of the peace, and a first-degree misdemeanor of resisting an officer without violence. We'll tackle the failure to appear first. Judge Dyer has already set a hold without bond for failing to appear for a pretrial conference. So I don't have the authority to do anything different on that. That's going to be something you're going to have to take up with Judge Dyer. All right. Ms. Amber, any history or FTAs?
Other than the DUI issue, Texas 24 ag assault ×2, resisting 22 DUI, 21 abandon danger of a child, tampering with a witness, obstruction 19, 18 domestic, felony back criminal mischief.
All right. Ma'am, I see here that you have a Texas driver's license. Do you have any ties to the area?
All my family lives here. I'm just moving back to the area and trying to get settled back in to live near family.
How long have you been in Bay County for?
I've been traveling back and forth between Texas and here since September. And I just resettled back in March when I got this DUI originally. That's when I started the process of living here permanently.
Okay. Well, before we get to that, I have reviewed your criminal indigent form, and it says here that you're seeking a court-appointed attorney. Is that correct?
Yes, ma'am.
Okay. And it says on here that you have 0 dependents and 0 take-home income. Is that correct?
Yes.
Okay. Based on that information, I will find that you are entitled to the services of the public defender and appoint them. Okay. All right. So as I mentioned, for the failure to appear, that's a hold without bond. But for the new charges of breach of the peace, I'm going to set $1,000 bond. And for resisting without violence, I'm going to set a $2,500 bond. Even if you make those bonds, ma'am, you're still held without bond with Judge Dyer. So it may be in your best interest to just move forward with that. All right. I'm also going to order, if you do, as another condition, if you are able to make bonds or actually resolve the hold without bond, that you are to stay away from the takeoff food and gas store where these charges are alleged to have occurred during the pendency of this case.
Yes, ma'am.
Okay, so that's a total of $3,500. Your next court date for the FTA is July 15th at 9 a.m. And your next court date for your new charges is June 10th at 8:30 a.m. Thank you, ma'am.
Step to your right to the T. When the green light comes on the sign. Next, step on the red X, ma'am. Here you go. Face the TV and state your name. Patty Dawson.
All right, Ms. Dawson, good afternoon. You're here for your first appearance. I understand the jail has informed you of your rights, but in the event you need to be reminded, you have the right to remain silent, right to counsel, and right to communicate with counsel, family, or friends for help. You have two charges, a domestic violence battery, which is a first-degree misdemeanor, and a possession of marijuana no more than 20 grams, which is also a first-degree misdemeanor. I've reviewed the affidavit and complaint, and I do find probable cause for these arrests, for these charges. I've reviewed your criminal indigent paperwork, and it states that you are seeking a court-appointed attorney. Is that correct? Okay. It states here that you have one dependent, but take-home income of $0. Is that correct?
Yes, ma'am.
Okay. Based on that information, I will find you indigent and appoint the public defender to represent you. Okay. Any history or FTAs?
Just a domestic and 20.
All right. I'm going to set the following bond amounts. $5,000 on the domestic violence battery and $500 on the marijuana charge. I'm also signing a no contact order in this case, Ms. Dawson, for the duration. Well, let me back up. If you make these bonds and you leave jail, you're ordered to go to the pretrial release office in the Bay County Courthouse by 9 a.m. tomorrow morning. This no contact order states that you shall have no contact of any type with the victim who is listed as Maurice Youngblood, except through proper pretrial discovery. This order is enforceable for the duration of pretrial release or until it's modified from the court. And no contact includes oral communication, in person, through text message, phone calls. You also cannot get third parties to contact Mr. Youngblood. You can have no contact with him whatsoever. Do you understand that, ma'am? Is that a yes?
Yes, ma'am.
Okay. And as a reminder, any contact with Mr. Youngblood or attempted contact could result in violation of your bond conditions. All right, ma'am, your next court date is July 17th at 8:30 a.m. for both of these charges. Thank you.
Step to your right to the T. When the green light comes on, sign. Next, here you go. Red X, face the TV, state your name.
Aaliyah Serbia.
All right, Ms. Serbia?
Yes.
Okay. Good afternoon, Ms. Serbia. You're here for your first appearance. I understand the jail has informed you of your rights, but in the event you need to be reminded, you have the right to remain silent, right to counsel, and right to communicate with counsel, family, or friends for help. Ma'am, you are charged with a battery, which is a first-degree misdemeanor. I've reviewed the affidavit and complaint, and I do find that there is probable cause for this charge. I've reviewed the indigent application form, and it states that you are not seeking a court-appointed attorney. Is that correct?
Yes.
Okay. Is there any, and I will note, if your circumstances change in the future, you can always reapply. Do you have any history or FTAs on this individual?
No, ma'am. No, ma'am.
Okay. Ma'am, I see here that your address or your given address is in Alabama. Is that correct?
Ma'am.
Is that a yes?
Yes, ma'am.
Okay. What ties do you have to Bay County?
None, I was just here for vacation.
Okay. Okay, I'm gonna set the following bond on the battery, $5,000. If you bond out prior to your court date, you'll have to report to the pretrial office, which is in the Bay County Courthouse by 9 a.m. the next business day. And I'm also going to order that you have no contact with Rachel King, who is the victim in this case.
Yes, ma'am.
All right, your next court date is July 17th at 8:30 a.m. Thank you, ma'am.
Copy. Step on the edge, ma'am. Here you go. Face the TV and state your name.
Please forget.
All right, Miss, is it Burgett or Burgett?
Forget.
Okay, Miss Burgett, good afternoon. You're here for your first appearance. I understand the jail's informed you of your rights, but in the event you need to be reminded, you have the right to remain silent, right to counsel, and right to communicate with counsel, family, or friends for help. You are charged with 1 count of domestic violence battery, which is a first-degree misdemeanor. I reviewed the affidavit and complaint. I do find there is probable cause for this charge.
Yeah.
Okay. Any history or FTAs on this individual?
Got her on probation. Last year, false ID, grand theft auto, 24 grand theft auto, DWLSR, 19 petty theft, controlled substance, 15 of petty theft, and an ag bat and 11.
And I apologize. What is she on probation for?
The grand theft auto.
Okay. Thank you. All right, Ms. Burgett, a couple of things. I'm going to set a bond in this case. Well, actually, let me back up. Hang on. I've reviewed your application for criminal indigent status, and it says that you are seeking a court-appointed attorney. Is that correct?
Yes, ma'am.
Okay.
Yeah.
I show here that you have 5 dependents and 0 take-home income. Is that correct?
Yes, ma'am.
Okay.
Yes, ma'am.
All right. Based on that information, I will find that you're indigent, and I will appoint the public defender to represent you. All right. I'm going to set a bond of $5,000 on the domestic violence battery.
Ma'am.
I'm also going to sign a no contact order that states that you shall have no contact of any type with the victim, who I have listed as Daryl Wilburn in the affidavit and complaint, except through proper pretrial discovery. And the order is enforceable for the duration of the pretrial release, or it is modified by the court. No contact means no contact whatsoever. In person, over the phone, text message, through social media. You cannot have third parties contact them on your behalf. If you do any of that, that could be a violation of your bond conditions. Do you understand that, ma'am?
Yeah.
Okay.
Yes, ma'am.
If you are to make that bond, well, before I say that, as you just heard, the information I have states that you are on probation, and this new law violation is a violation of that probation. So I'm going to be signing a warrant that will hold you without bond until you can get back before that judge. It's a felony case in case number 24-1968CF. And your attorney can always communicate with your judge in that particular case regarding your bond and any conditions, but that is a violation of that condition. So I've signed that as well. Your next court date for the misdemeanor charge is July 17th at 8:30 a.m. But again, I have signed this warrant, so you're going to be held on that Do you happen to know the date for the felony? She'll come back tomorrow. Okay.
She'll come back tomorrow.
Okay. So
Yeah.
we'll see you tomorrow to set that court date, ma'am.
Step to your right to the T. When the green light comes on, you're gonna sign for your copy of it.
Okie dokie, friends, that is a sampling via the Wayback Machine of Judge Carruthers. Again, she was sworn in yesterday and immediately went to work. So, a new judge for us to follow. She's in Bay County. Okie dokie, let's go back to Michigan. We'll check back in with Judge Middleton. New set of contestants there.
Good morning, sir. Let's see if they put this in my queue. And Jenny. Give me a minute. Hayden Gore. I'm sorry, I mispronounced your name. All right, let's talk about this. This was not on my calendar, but you're here. And we tend to try to take care of people when they do come in. Your dad gave you some good advice. This alleges that on April 9th, that you assaulted Anthony Robert Elliott. That's assault and battery. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. First thing there was a recall of warrant for your arrest. According to the affidavit that accompanies this happened at Sturgis High School. The non-aggravated assault was between two students, Aiden Gorham and Anthony Robert Elliott, and a witness in the weight room. Anyway, the charge is assault and battery. It's a misdemeanor, as I said, punishable by up to 93 days in jail, and a fine of up to $500. How do you plead to that charge?
Not guilty.
All right, I'm show a plea of not guilty. I'm gonna appoint an attorney. Set attorney pre-trial for 6/26/26 at 8:30. We're gonna get a lawyer to help you with this. It looks like just school stuff, but the prosecutor felt strongly enough about it that they charged a criminal complaint. Who authorized it? Angelique Canfield. So we're gonna need more information. I'm gonna set bond at $250 PR, and it needs to get printed. All right, I've recalled the warrant that was out for your arrest. I've showed you pled not guilty. I gave you a $250 PR bond. I don't want you to have any contact with this other kid. Anthony Elliott. School's out for the year. Did you get a school consequence? Did you get suspended or anything?
Yeah.
For how long?
I believe it was 5 days.
Often that would be enough to resolve it, but apparently the prosecutor felt strongly enough about it to charge a criminal offense. All right. I didn't get an advice of rights from you, but that's all right, because we didn't do a plea. I'm gonna send you out to the court office. I'm gonna give you some paperwork. You're good. You can set up in there. Yes, I'm assuming that. It's Gary, I think. Anyway, I'm gonna give you this information with your lawyer's name and number on it. I want you to call the lawyer, take an appointment to discuss it with him prior to that 26th of June date. All right, you gotta sign a PR bond and you gotta get fingerprinted, then you're good to go. All right.
TCF Live on a lovely, lovely Tuesday now in hour number 2. Let's go down to Louisiana and the board. I'm just glancing up at this this inmate that they're talking to, and he's very animated. Seems like he has a lot to say, talking with his hands a lot. So I'm curious. Let's see what's going on.
And we are going to be holding a hearing today at East Baton Rouge Parish Prison. But before we get started, I'd like for our staff to introduce themselves. Desmond Thompson. Sherelle.
Francis Abbott.
The time is 8:47. And Captain, would you introduce yourself there at East Baton Rouge?
I'm Captain Miles, Chief of Intake and Release here at East Baton Rouge Parish Prison.
Thank you, Captain. Today we're going to be hearing Mr. Devontae Carter. Mr. Carter?
How you doing today?
Doing well, thank you. Would you please introduce yourself with your name and your DSC number?
Okay, my name is Devontae Carter. My DOC number is 767178.
Okay. Mr. Carter, do you have before you a questionnaire, revocation questionnaire that you recognize your signature?
Yes, ma'am.
Okay. Your answers to that questionnaire indicate that you are not eligible for appointed counsel. Have you hired an attorney for today?
No, ma'am.
So we're going to go ahead and get started. You are alleged violating your conditions of parole. It looks like you're a third-class offender. I'm going to ask Mr. Tillis, who is on my left, to begin your questioning. I also want to note that Mr. Barra is on my right, and I'm Ms. Ledoux, and we're the committee panel for today. Okay?
I understand.
Okay, Mr. Tillis.
Good morning, Mr. Carter. How are you?
I'm all right, sir. And you?
Good. I'm going to read some violations, and you can plead guilty, not guilty, or with a statement.
I understand.
Violation number 2, you failed to submit any monthly reports since 7/29/2025. As a result, you absconded from supervision. A parole warrant was issued for your arrest on 12/16/25. How do you plead? Guilty, not guilty, or with a statement?
I'd like to plead guilty, but would I still be able to make a statement regarding that?
Sure. Go ahead. Tell them.
So just for we're all on the same page, before I got released from West Baton Rouge Prison, I had immediate release due to the GED program that I completed. I was informed that upon my release, I was going to get all the documentation to be able to set myself. But before the release, I also applied for an interstate compact through the GED teacher. I was given the paperwork. I filled out the paperwork to go to New York City, and I assumed it was submitted. Upon my release, when I went to the parole office, I was informed that no one ever submitted the interstate compact, and I therefore asked for an interstate compact to be filed. When I asked for the interstate compact, I was told that I had to have a job in the state first and then I would get approved for it. So I asked for a 30-day travel pass. I got the travel pass. I went to New York. I achieved getting a job through an Arabic friend that I have that owns a convenience store, and I had an address. When I came back to Louisiana, I informed them of this. They told me that that was not legitimate enough to get an interstate compact. So I asked them, what would I have to do to get an interstate compact? They said I would have to get a legitimate job on the books. So therefore, I asked for another travel pass. I informed them that the address that I was staying at was somebody that I barely knew. I don't know anybody in Louisiana. I didn't grow up here. I just came here to work. You know, I informed them that I wasn't comfortable where I was staying at and that I was trying to move to New York because I had nowhere else to go. I asked for another travel pass to go get a job. They told me they're not going to just keep doing travel passes and to get in contact with my PO. I can have Miranda I don't know if she's in the top corner or not, but I can have Miranda, which is my fiance from New York. She can show you my phone. I have multiple messages to my PO. I have multiple calls to my PO where I tried to get in contact with him regarding the interstate compact. I tried to get in contact with the supervisor. The voicemail box was always full. I made it upon myself at that last date, which was 7, I believe 29 or something like that, where I went and checked in and I asked for the interstate compact again. I even demanded them. I told them, I said, I'll stay here until my PO comes just so I can make prior contact, like initial contact with my PO. They told me, oh, call him. You can't just stay here all day, etc. I currently just did 2 years in jail or prison, as you would call it. And I ran into a lot of altercations because of the simple fact that I'm not from here, you know, and I made them aware of this. I told them, just coming to the parole office alone, I feel like my life is in danger because I don't know nobody. You know what I mean? Anybody could be an enemy, anybody could be a friend of a friend, you know? And I told them, I'm trying to make it as urgent as possible for me to leave, please. I was once again ignored and told to talk to my PO. So honestly, I'm pleading guilty because I did take it upon myself to leave, but I honestly felt like I left for my safety and for my well-being. I went to New York, I got a job, I worked, I stayed out the way. Now, was I wrong for not reporting and informing my PO? But the whole time I was up there, I tried. And that's just the God honest truth. So yes, I do plead guilty to that count.
Okay. On violation number 3, you failed to maintain a valid address where you could be supervised and moved out of the state of Louisiana without permission. Additionally, you were arrested in New York by the Cheektowaga Police Department on 12/28/2025 for felony, third-degree burglary, misdemeanor, vagrancy, and misdemeanor disorderly conduct. As a result of your absconding from supervision, a parole warrant was issued for your arrest on 12/16/25. How do you plead? Guilty, not guilty, or with the statement?
I'd like to plead not guilty and have a statement also, if you don't mind.
Go ahead, tell us about it.
Okay, so with this situation, basically it was a misunderstanding at Walmart where I paid for half cash and half like through Walmart Pay. I guess security team must have assumed that I didn't pay for anything at all. And when they approached me on it, they basically upgraded the charge from a theft to a burglary due to the simple fact that I wasn't supposed to be at Walmart. So therefore, when I went to court for that situation, the judge understood the situation and how it worked out. And I got it all the way. I took no conviction. I got it reduced all the way down to a $250 fine of disorderly conduct. So I don't honestly want to plead guilty to that because I didn't take those convictions. I was even picked up from Buffalo with just a fugitive warrant. If I still had those open charges, the timing is too close for me to you know what I mean? I would have either had to take a conviction or I would have had to still have an open case. I have neither or.
Why were you not supposed to be in Walmart?
Because in my prior history, I got banned from Walmart for a theft charge.
In that state or what state?
That was here in Louisiana.
You do have a conviction for disorderly conduct.
It's a conviction. I was told it was a $250 fine.
You gotta plead guilty or be found guilty to be able to be fined. So you got a reduced charge. What it looks like to me is you got a reduced charge of disorderly conduct and you plead guilty to disorderly conduct and they reduced that, they dismissed others.
And it doesn't show as a fine. I recently spoke with my parole officer and he said that he called Cheektowaga and he could not find a charge on it. He said that it was reduced to a fine also.
So you had an attitude when you got arrested?
No,
Disorderly conduct, I just wondered.
I'm not sure how that goes, but I didn't like fight with the officer or argue with the officer.
How you think you got the disorderly conduct?
I'm honestly not sure, to be honest with you. It's probably just because of the situation, how it played out or whatever it may be, but I didn't reject anybody in any type of way. I even took guilt and paid for whatever the remainder was.
Danny, you got any? No. Okay, violation number 4. You were arrested in New York. Pronounce that.
Cheektowaga?
Cheektowaga
Yes, sir.
Police Department on 12/28/25 for felony 3rd-degree burglary, a misdemeanor, disorderly conduct misdemeanor. The charges for the FBI rep sheet is for the Cheektowaga Town Court that the charges have been disposed by a guilty plea on 1/29/26. The entry list of the charges disorderly conduct created a hazardous or offensive conduct in New York. The severity of the charges is listed as a violation of the sentence is listed as custodial discharge and a fine of $100. How do you plead guilty, not guilty, or with the statement?
I'm sorry. Are you asking me if that's what happened, basically?
Are you guilty of being arrested for those charges in New York? You just explained what happened, so.
Yeah, as in not a conviction, just arrested.
Okay.
So you're pleading guilty?
Basically, yes. It's that's not agreeing that I took the conviction, correct?
Yeah.
It is. It's saying that you had a fine, that you were involved
Okay,
with.
yes.
Enforcement. That happened. Okay.
I just didn't want the burglary tied because that brings it to a whole nother level.
Right.
Violation number 10, you're currently owed $296 in arrearment toward your supervisional fees. How do you plead guilty, not guilty, or with the statement?
I plead guilty with the statement. I'm not sure if did that come before or after the warrant?
That's the accumulation of your fees that have not been paid since you've been released.
Because I've paid the majority of them. I don't understand.
It could have been since you've been, well, it's $65 a month, so back.
I understand. Yes, I plead guilty to it.
You also cost the state of Louisiana $3,180 to bring you back to Louisiana for your absconding.
Oof.
That's the cost to the state for getting you, because you did not comply with being where you were supposed to be. We had to go get you and bring you back.
Can I make a statement regarding that?
What?
To my knowledge, I was honestly looking at the EBR website under the warrant search to see if something led to me having a warrant. And I never seen one, but I didn't have knowledge that it wouldn't pop up on there. But if I did know, it's not something that I was running from. I've honestly took the risk of coming out to New York and getting the absconding. It's not like I didn't have knowledge of it being an absconding, to honestly reach somebody that could help me get the interstate compact.
Okay. So your warrant was 12/16 of 2025. We have Miranda Alls, who would like to speak on your behalf. Ms. Alls, at this time, you're welcome to address the panel.
Yeah, so I am his fiance, Devontae Carter's fiance. I would like to state that several times he had tried to reach out to the borough board in regards to an interstate compact. We are getting married. We would have been married had he not had a warrant and was arrested. However, he's tried to reach out to his parole officer on a regular basis, even when he caught the charge in Cheektowaga and there was no response to him. So he was never aware of this warrant that was issued due to his parole officer not staying in contact with him.
His parole officer staying in contact with him. Okay.
Or like he was trying to get in contact with his parole officer. We've been together probably about 8 months now, and several times he was calling. I've even called his parole officer myself and can't get in contact with him. I've sent emails to him, can't get in contact with him. He's paid. Not all of them.
Officer? Who were you trying to reach? What was the name of the parole officer?
His name, you mind if I speak?
Noah,
I'm asking her.
Noah Brown.
Noah Brown. Okay. Thank you for your comments. Mr. Tillis, do you have any further questions for Mr. Carter?
You had said earlier that you were in fear of your life. Why was that?
As I said, I got into a lot of altercations when I did do the time that I did. And when I tell you I don't know nobody in Louisiana, I don't know what street I'm on if I was to get released right now. I don't have too much knowledge of Louisiana or the people in it. And I've received a lot of threats when I was in prison. And I just felt like every time if I come to the parole office and I see somebody that I was in prison with, it's a matter of time before I run into the person that I had a problem with. You know what I mean? And I really felt like I was outnumbered. Like even it takes, like it's a very dangerous city, if I just be honest with you.
Did you inform your parole officer about this?
My first time speaking to my parole officer was at the preliminary hearing. That's the first time I was ever able to get in contact with him. But I did go to the board and inform them that that date 7/29, I believe it was, where I last checked in. I did inform them. I said that I'm in fear for my life and I'm trying to do anything to get out of the state. What do I have to do? And they basically kept telling me to get in contact with my parole officer. If it matters, she can show you on my phone. She has my phone. She has possession of my phone. She can show you all the messages where I tried to reach out. I've tried to call. I've tried everything in my possibility to reach.
Is it true that at 7/29, when you reported you tested positive for marijuana?
Yes, ma'am.
You knew that was not part of the conditions of parole as well, I'm sure.
I understand.
I mean, takes two to tango. I don't understand.
If I'm being honest, man, I'm honestly trying to put this chapter behind me in my life. I took this charge really to keep my kids out of the way of DCF and etc. And I'm getting the worst end of the stick. I'm trying to better myself.
Charge was cruelty to juveniles.
Yes, ma'am. But there was no signs of abuse or anything. I took a guilty plea on my arraignment. I just took the charge just to keep my kids. I grew up in foster care my whole life, man. I've been in foster care since I was 3 months. I got adopted. I got abused 4 years of my adoption. I don't hit my kids. I don't believe in that. I wouldn't, I didn't like it when somebody did it to me. I wouldn't do it to my own, but just circumstances led to the situation, and I was the person at fault, so I just took the conviction. I sent my kids back to New York City and I took the conviction. It wasn't the smartest thing to do. I could have fought the case and potentially won it, but I didn't want my kids to be involved with any type of child and family services, because that's I feel like I'm a generational curse if I do that.
How many
in my life.
convictions have you had in New York?
In New York, I've had no convictions in New York. Any of my priors
out of that, have at least one, because there's one that you pled guilty to right here. So you need to get that straight. You pled guilty to disorderly conduct on whatever. You keep saying you never pled guilty, you never had a conviction. Well, yeah, you do.
Well, my apologies. In that case, I do.
I want to straighten you out on that one because you can't keep.
I understand. I'm trying to be as straightforward as I can. Like I said, I'm just trying to close this chapter in my life. I know I still have to do parole. I know I can't fully run away from it, but I'm giving you the God honest truth. I've been trying. I tried my hardest to leave the state as legally as I could. I tried my hardest I really thought in my mind that when I got out of prison, this was all going to be somewhat handled for me. I got a place that I could sleep on the couch for a few days to a month until my situation got situated, and it just nothing worked out for me. I didn't have any money for food. I didn't have money for anything. And like I said, I'm in a state where I know literally nobody. When I went to New York, I got a job. I was working the whole entire time. I worked construction. I worked in warehouses. In that short period of time, I was in New York. So it's not like I can't better myself. It's just that I'm a product of my surroundings right now, and I'm trying not to be.
I got you. I'd like to ask to go into executive session for a moment.
I second.
Ms. Jim,
Yes,
Tillis,
Yes.
Bauer.
Yes.
we'll be right back. We need to discuss confidential information.
No problem.
Wahoo, I believe you smelled it. You said, I feel an executive session coming on. Oh, well, here it is. So we'll come back. In the meantime, Texas is starting to fire up. So let's go to Judge Stevens.
What are you crying about? We hadn't even started. We hadn't done anything. We hadn't done anything. She's what?
I'll say you're kind of scary, Judge.
I scare her. Well, I am able to go at Halloween without a mask. I mean, seems to frighten a lot of folks, but.
Oh, sorry.
All right. Well, I mean, this is what we do every day. These cases, thousands of them. We have thousands of them. Just folks get in here and generally fix everything. It gets fixed one way or the other. It gets fixed, and people generally leave here feeling better about themselves and taking care of problems that everybody makes problems. Everybody has problems. That's the way the universe is. Nobody's perfect. But it's how you deal with the problem. That's the real test. So you're charged with a state jail felony here of interference with child custody. And it carries with it up to 2 years in the state jail. It's the least serious of felonies, but nonetheless, it's a felony which you don't want to have on a record. Do you have a criminal record at all? Well, fix this, deal with it responsibly. Now, Mr. Adams is going to be helping you, right? Okay, right. You have to speak out so she can take everything down. Okay. Langston, this is initial docket, right?
Yes, sir.
Okay, she just got indicted in April. So we're going to set this to an announcement, but y'all working on.
Yeah, I think, Judge, with this being interference with child custody, there's a psychosocial report that she's.
Say that again.
I think it's a psychosocial report that I believe she's gonna get to me.
Psychological.
Psychological.
Yeah, psychological.
Oh, yeah, psychological. And I'm gonna
Duplicating your psychos.
get that to the state because I think it was a reason why that the children weren't turned over. And that might help with resolution on.
Okay. So.
But I just want to put it on the last one.
Yeah. Stand by, just want to give us. You got a probable cause affidavit?
I have it right here.
You have it right there.
This is it.
All right. What's this all about here? Okay. Police arrived on the scene, entered your residence, which reeked of marijuana smoke, and then they located a bag containing a green leafy substance recognized to be marijuana. Is that in the home?
I was told that.
Was that, this a yes or no? Is that no? With where you and the children live?
I was evicted and my kids were.
Ma'am, where you and your children live?
My children were with one.
Do your children go to that home?
We were moving.
Is that yes or no? Do your children go to them? Okay, so they were still living there. That was their residence. Is that yes? You have to speak out. That's the way it's, yeah, and use English. That helps us. Okay. Well, I don't like that. Well, you can be sorry, but it's your children. You're foremost responsible as a parent. And illegal drugs around children are forbidden. Much less it's poor parenting. You're supposed to set a role modeling example. I mean, yeah, there's. Are they working on that too? Is she getting charged with drugs or something?
No, don't start.
Why wouldn't she? I mean, it's in the room. It's in the house there. It's marijuana with kids. I mean, this is still new. That has no purpose.
Yes.
And what happens is you open the door for all kinds of things, like where are you getting it from? Take a polygraph to whether you're telling the truth or not. And then you get deeper and deeper into a hole. But you have children. What are their ages?
8.
8 and 10. Their priorities need to be fixed. You're third. Your children are first. Others are second. You come in third. That's the way it should be. That's selflessness versus selfishness. I'm sure the drugs aren't for the kids, right? Well, that kind of narrows down the field.
She was arrested for possession of marijuana that day.
Shame on you. That's just shame on you. You're supposed to be an example. Well, you can cry all day long, but what are you crying about? You got caught? Fix this mess. Do you understand? On my watch, you're going to fix it. I guess you have to speak English too, so the court reporter can take things. Okay, that's how we do. Yeah, they don't take nod. And everything that's said in the courtroom needs to be transcribed and recorded by the court reporter. All right. So get a resetting announcement and fix this mess before you free fall into the great abyss. You know what I mean?
Yes, sir.
And lose a very precious parts of your life, which can be at risk for this behavior.
Yes, sir.
All right. We're resetting.
Thank you, Judge.
Yeah.
Hey, how we doing? Last time on that other stuff we had earlier, we said we were gonna try to run some cases through here soon. Yeah, with a bunch of stuff. Yeah, okay. Alicia Simeon is reset. I've got Joshua Curtis on some cases. That's Mr. Kelly. It's odd. Mr. Kelly was here all week long in the trial, so we get him on a docket, and he's not around. He must be. But well, he was certainly here during the whole trial.
Alrighty, friends, we've reached the halfway point of TCF Live. Let's go back to Louisiana. The board is back from their executive session.
Executive session at 9:09. Mr. Carter, it concerns me that you have this extradition fee. And I think that I have a solution for that. And so my vote today is going to be to, in lieu of revocation, you're still going to be taken back into DOC custody or remain in DOC custody, but go to a transitional work program for a period of 6 months. And during that time, you'll be able to get enough money for your extradition fee and work on your interstate compact. So my vote is in lieu of revocation, go to a transitional work program, and you cannot leave the state until your extradition fee and your fees have been paid. Okay? That's my vote. You better be careful because it could get you in trouble if you talk too much.
He's muted.
Mr. Tillis,
I concur.
Mr. Barra,
I concur, but cannot leave the state until ICOTS is approved.
ICOTS and the extradition fees.
Okay, so is this necessarily a 6-month sentence?
It's 6 months with you being incarcerated doing a transition work program.
As in work release?
And work release, that's correct.
Okay, and just because I had some complications the last time I was in prison, how soon would I expect to get results as far as that goes?
We're going to let you go and let the facility deal with that. We've voted. Thank you very much.
No problem. I appreciate you guys. Thank you so much.
Okie dokie, so that's what went on there. Let's go back to Texas, but this time we will check in with Judge West.
Yeah. Surely he's sober and awake today.
He was this morning when I talked to him. He's probably just still tired. I've gone over the probation letter about safety and he's fine with that.
Let's wait for him to get out here. Morning. You are Aaron Wars. Feeling better this week, Mr. Wars? So, Mr. Wars, this is cause number 25 DCCR 1253. Previously, you were in court, entered a plea of guilty to driving while intoxicated, third or more, received that pre-sentence report and reviewed it. Have you both had an opportunity to review that report?
Yes, Judge. Yes, Your Honor.
In addition to that, we received an we received an update, also a memo from probation, I believe it was yesterday or late last week, and you both had an opportunity to review that as well.
Yes, Judge. Yes, Your Honor.
And so Any other issues, Mr. Smith? Obviously, based on the issues last week with Mr. Wars testing positive, there's clearly a need for some intensive treatment. Any reason though not to go along with the agreement still?
No, Judge, I think we would amend it because we did not have treatment involved. We would ask for safety placement. Your Honor, I've gone over with Mr. Wars and he agrees that he needs safety.
Okay. So Mr. Wars, we're going to give you this opportunity today and I hope you take advantage of it. Because if you don't, things could be a whole lot worse. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, in accordance with your agreement, find you guilty of driving while intoxicated, third or more. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. You follow all of these and do everything that you're supposed to. This is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence that you've already agreed to. Do you understand? I don't see the certification attached to this one. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, good luck to you, sir. You can go back with the bailiff.
I'll be able to see you, Jeff.
See, Ms. Delays, you've got Howard Walker Jr.
Yes, Your Honor.
Morning. Morning.
So you say. Way down the road.
Right here, Mr. Walker.
Good morning. You're Howard Walker Jr.
Yes, ma'am.
This is 26 DCCR 0082. Mr. Walker's charged with injury to a child, elderly, or a disabled individual. It's a first-degree felony. What is the announcement?
Your Honor, we'd like to ask for one more reset. I've just gotten all of the discovery. Need to go to the jail and go through it with him. I think, Luke, Mr. Nichols agrees with me on this because he's got his.
I know they had to copy a lot of media.
Okay.
And so it's ready, and I think she either has it or.
I have it,
So.
but I haven't gotten to show him and I've only gotten about halfway through it.
Okay,
Quite a bit.
so we'll do one last reset. And so between now and that next court date, Ms. Delays, you'll be out to the jail to go over everything, show you everything that she's received. And then we'll get an announcement at that next court date after you see everything, if you still want to go to trial or if there's some agreement that gets worked out. Okay. All right. We'll see you at the next court date.
Thank you.
Thank you. Yes.
Barbara, thank you for the $10 super chat. Continued prayers for Wahoo. I wholeheartedly agree. Keep getting better, my friend. We appreciate having you here and wish you all the best.
Good morning. Look at you doing your certificate. So there's no agreement. We're just going to go through the motion.
Yes, sure.
Okay.
It's going to play true to 33.
Okay. I'll go through all of them and we'll figure out what we need to do. Good morning, sir. You Bradford Josie?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Josie, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And in cause number 25, DCCR 1062, I have a motion to revoke your community supervision. Shows that you were placed on probation October 14th of 2025 for the state jail felony offense of burglary of a building. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, a Class A misdemeanor, February 22nd of 2026 in Jefferson County. And is that true or not true?
It's true.
Count 2, bless you. Are we changing? Are we?
I'm playing not true to first and second.
Okay.
I'm sorry, I didn't understand.
Count 2 alleges that you committed the offense of burglary of a vehicle March 9th of 2026 in Jefferson County, Texas. And is that true or not true?
No.
Count 3 alleges that you failed to report to the probation office as directed November 18th and December 11th of 2025, and then January 6th of 2026. And is that true or not true?
True.
Count 4 alleges that you failed to report to the probation office for your administrative hearing on February 12th of 2026. And is that true or not true?
It's true.
Count 5 alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 7 alleges that you were at a location other than your residence at approximately 3:25 a.m. on March 9th of 2026. And is that true or not true?
That's true.
Count 8 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
That's true.
And then count 9 alleges that as of February 12th of 2026, you were $700 behind in your court assessed fees. Is that true or not true?
Yes, ma'am, that's true.
Did you enter your pleas of true to counts 3 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Now, I don't want to get into, I'm not asking any questions, but with regard to counts 1 and 2, I do want to make everyone aware that if we come here and there's a hearing and you act, I don't want us to have to come and have a hearing, have officers come, if in fact there's something that is blatantly true. It's not going to help you if you're not taking responsibility.
Yes.
If you actually didn't do it, that's fine. That's what the hearing's for. But just to not take responsibility doesn't sit well. Does that make sense?
Yes, ma'am.
All right. So are we good with what we played on then?
Yes, ma'am.
Okay. Then I'm going to find that you entered your pleas of true to counts 3 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I am going to reset your case for a hearing so that the state can bring witnesses with regard to counts 1 and 2. We'll get an updated pre-sentence report done. And I'm guessing
Not long, Judge.
not long, so maybe even on 11 o'clock.
Yes, ma'am.
Okay, so we'll set it on a regular docket date at 11 so we can have any witnesses. Anything that you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me on your behalf when we come back.
And just for the court's information, Judge, once we have those underlying issues dealt with down the hall, then those pleas will change. So it's I'm just giving you a heads up, because if we set it for a hearing right now today and we're able to get those dealt with beforehand, then we're subpoenaing witnesses when a hearing wouldn't meet.
Well, that's why I'm saying I don't want to do that. So if they're true, they're true. I don't want to, I mean, if you need time to take care of something, that's one thing, but to stand and swear under oath that something's true or not true is putting Mr. Josie in a position of, I don't know what you mean by taking care of them, but if he's gonna go plea on some cases down the hall and he just said under oath that it's not true, then we have an issue.
I would like to establish, on my square.
Hold on. I want you to talk to Mr. Wilkerson. Let's figure out the timing of all this because I don't. So, I don't want him to have to subpoena witnesses. I don't want to get close and then we keep doing this and we show up and then there's some deal that's made and we've got officers who either just got off a night or whatever that had no reason to have to be here. So, I've taken the pleas. I'm going to reset it at this point for a sentencing hearing. However, I want to know within at least a week before that hearing, if I want Mr. Coleman to know if he has to get those witnesses here.
Yeah.
At least 7 days. Okay, all right. You can go back with the bailiff.
Thank you.
Thanks, Tiff.
Thank you, Your Honor.
Yes, sir. We're gonna set for that and then we're gonna hopefully hear what we need to, or I'm gonna be very excited.
All right, it might be a few minutes before she gets another contestant. Let's go back to Louisiana because they've got somebody new racked up. So let's see what that's all about.
Is impaneled in Baton Rouge at headquarters. On my left is Mr. Tillis. To my right is Mr. Barra. I'm Ms. LeJew. And we're going to be hearing an offender at David Wade Correctional Center. With the staff there at David Wade, introduce yourself.
Michelle Dozot, Warden. Brenda Ackland, Deputy Warden.
Ryan Kimball, Assistant Warden.
Anna Ralston, Classification.
Right before we show you.
Thank you very much. We appreciate you gathering today. We're going to be hearing Mr. Raymond Demalian. Mr. Demalian, would you introduce yourself with your DOC number?
My name Raymond Demlin, 424061.
How do you say your last name?
Demoland.
Demalian. Okay.
Yes, ma'am.
Thank you. I want to make sure I said it correctly. I'm going to read a little bit of information from your file, and then we're going to begin our questioning. It looks like you're a second-class offender, currently serving a 31-year sentence for armed robbery, 3 counts, and some illegal drugs. You have a parole eligibility date of 1/21/26, a good time date of 6/6/29, and a full term date of 2/23/35. Does that sound correct to you?
Yes, ma'am.
Okay. Warden, before we get started, I would like to ask you if you can give us a little insight. How long has Mr. Demalian been with you?
He's been here at David Wade since 2023. And since he's been here, he's completed several different programs: parenting, anger management, victim awareness, reentry, and thinking for a change, and also received his culinary certificate since he's been here.
Well, you've been to work, haven't you?
Yes, ma'am.
All right. Let's see. We have some people who are here in support of you, and we're going to allow them to speak as well. But I'd like to hear from you first, Raymond. Why do you find yourself incarcerated, And how long have you been down, and why should we consider early release?
What the first question was?
Why are you here? Why should they consider granting you today?
I'm here because of my charge on robbery.
Do you want to read that? You can ask them if you can read that.
Yeah. Can I read what I have on paper, if you don't mind?
Absolutely.
All right. Okay, because I'm not the same person that I was back in July 2004. I no longer believe that robbery should be a means to provide for myself. I've changed, I grew up, I'm responsible now. After almost 22 years, I can honestly say that I've grown up to be a more mature person. I've had a chance to really look at the life that I was living and the life that I lived since I've been incarcerated and truly see the negative effect my decisions had on the lives of others. I can see now that I wasn't thinking. I can see now that I wasn't thinking at all, just getting high, selfish, and ignorant about what life is really about. I learned that my actions always affect more than me, and I realize now that there is a certain amount of respect and love I owe to everyone. I know now that I'm responsible for making decisions that take the lives of others into account, that my choices can never be just based on how they will affect me. When I talk with my family, I can hear how much they need me, how much time I miss. I realize how valuable I can be to them and other people outside of my family because I want to be a positive influence on everyone I come in contact with upon my release.
You've been down almost 22 years, I'm 31.
Ma'am?
You've been down 22 years.
22?
Of a 31-year sentence.
Yes, ma'am.
Okay. Let's talk about something that's gonna be difficult. What happened in 2022? I need to know.
With your
write-up.
write-ups.
Which
Yeah,
one?
with your behavior, your write-ups.
Oh, back in 22,
Yeah.
you know, it was around the pandemic. And I was just going through a lot. Like, I was frustrated a lot, you know, couldn't find myself. So I started, you know, seeing that I was, man, I'm nervous right now.
Okay. Explain why you got all these write-ups. That's what they're at.
All right. I got the write-up because I wasn't thinking at the time, making bad decisions.
So what happened with the fire extinguisher? Tell me about that situation.
Oh, okay. Well, like I say, around pandemic time, I'm on quarantine in the cell. So I was trying to get out to use the phone in my phone time. So the officer came down and I asked him, like, "Sir, can I use the phone?" So he was like, "No." So I'm like, "Can you get some rank down here? I need to talk to some rank." So he was like, "No." So he left off the tears. So I had some tissue. I stuffed my toilet, started flooding my cell. So he came down and see me flood my cell. So I'm like, "Sorry, can you get some rank down here?" He still told me no. So I grabbed some tissue, lit some tissue. So he ran out the till, grabbed a fire extinguisher and started putting the fire out.
Okay, so that was before you took thinking for a change. What do you think now?
I'm a whole totally different person now. I can think before I react now. Back then I wasn't thinking about the consequences in life. I just was moving. Now since I took things for a change, it taught me how to be a better person and just think of the consequences before I start doing things now. That's what I learned from how to think for a change.
Okay.
Oh.
Would y'all want to ask before I ask his supporters? Okay, at this time, are you okay?
Yeah, go ahead.
Okay. I would like to ask Miss Charlotte, your mother, if she would like to speak to the panel. Miss Charlotte, you can go and just stand where you are and face us.
Yes.
And just tell us what you would like for us to know about your son.
I said, it's a wonderful son. He made a bad decision and what he did know was wrong what he did. But Raymond is a good child. I raised Raymond by myself. I tried. I did the best I could. But just child come home, got a home for I nephew, got a job for him waiting and all waiting because I love him. I'm so and he a whole different person now. I see. Back in the days, in the past behind. This is the future now. And we all love it. I love my son. His daddy went in his life. I struggled by myself, but I did the best I could.
Thank you.
And made a good job. You know, he just made a bad decision a long time ago.
Well, he's lucky to have you, Miss Charlotte. You're a good mama.
So I had to be here. I don't talk much about it.
I understand.
Thank you.
Well, thank you.
Mr. Brown, would you like to make a statement to the panel?
Morning. Trying to keep her together before we came here, talking outside the room and stuff like that, but I just want to thank God for the opportunity to inspire you to understand where we're coming from at this moment. We know that Raymond made those mistakes back then, and a lot of times, for us as young men, we think that guidance is what leads us in the right direction, but I think it's more inspiration. If we don't have things in front of us that inspires us to make better decisions, we tend to do things that either incarcerates us or causes us to lose our lives. And for me, that inspiration came from me having children. I had my first son when I was 19, and it started making me understand that accountability is going to be the biggest thing for my son growing up in this world, which is him seeing me doing better things. Raymond is like a brother to me. Me and him, I've been knowing him all of his life. And by us not having inspiration in front of us at all times, we had uncles that were successful and did things, taught us skills that would later on in life would be the things that we can build off of and stuff like that. But we were too much inspired by the things that we saw in front of us all the time. And those things tend to hurt us. You know what I'm saying? So for me, I gained my inspiration from my children, but at the same time, I wasn't always around Raymond because, you know, going to work and taking care of my children and stuff like that, it separated us, and the inspiration that was around him led him into different directions. Because me and him had the day he made his infraction, and I know that was one of the reasons why we didn't talk the first maybe 8 years he was incarcerated, because he knew I was gonna make a statement to him, which was, I told you not to go anywhere. And he's a man. We're both men. And I know my words at the moment didn't resonate with him, because after we had that conversation, the person that he was with, that he made the mistake with,
end up being that inspiration at that moment. And now in 2026, I don't involve myself with, whether you're family or not, I don't involve myself with those type of people. I'm a business owner. I work for LSU. I've been working for LSU for the last 15 years. Me and my wife been married, going on 15 years, August 4th coming up. And I know he has a good woman that he's coming home to that's going to help be that inspiration for him as well. But I'm going to be by his side. Going to be there. We were supposed to start this project Monday, but God paused that project for me to start at McKinley High School doing the floors over there until tomorrow, so that I can come here and try to give you an insight of where he's going to be at when he comes home.
Okay, so you have employment already?
Yes, ma'am. Yeah, I'm a business owner. I'm registered with the Secretary of State. We have our LLC insured. My company, he will be employed with me. So he's, until he does use his certifications to become a cook or whatever, because his niece, his sister's daughter, her father has a food truck. So maybe if he's not using the food truck, we can rent it from him and get him somewhere where he's totally engulfed in being successful. Okay. Instead of coming out here and not having any direction and stuff like that. So
that's helpful for our decision. Thank you.
Yes,
I think we've got enough information. I appreciate you both being here. We also have Mr. Kerry Myers with the Louisiana Parole Project. Mr. Myers.
Yes, good morning, Kerry Myers, with Louisiana Parole Project here for Mr. Demolin. Raymond has spent 22 years incarcerated. He was 22 years old when he became incarcerated. So he's literally been incarcerated as long as he was alive when he committed the offense. He's at an age now, and you heard from the warden about his programs. He's done the work. He continues to do the work. Parole Project is prepared to assist Raymond in his transition. He will be in our transitional housing for as long as this board would think necessary. We will provide him with mentorship. We will provide him with case management. He will have the advantage of having the programming and financial planning, literacy, technology, consumer skills, the whole gamut. He'll be evaluated by our social workers for any needs, any substance abuse needs or mental health needs. And we would then expect him to comply with any recommendations. He would be a part of this program. And as you know, Parole Project has been very successful. Obviously, nothing is perfect, but Parole Project has been very successful in helping people rebuild their lives. Raymond is ready to rebuild his life. This is a situation where corrections works, the programs, the time, the maturity. We're prepared to help Raymond in his transition as his forward to consider these things, consider the support system that he has, and grant his parole today.
Mr. Tillis, do you have any questions?
Yes. What impacted you the most in some of the classes that you took? Which one was stood out to you the most, Mr. Raymond?
Like anger management.
Tell me about it.
Because I didn't realize how deeply my problem with anger was within me until I started noticing all the trouble that I kept getting myself into behind responding heatedly behind small situations. I was so caught up into my own ways of doing things that I didn't see them as wrong. So this course really helped me open my eyes to the ways of my behavior and taught me how to make better decisions. My behavior changed for me when I took this course because my level of maturity grew. But my understanding of who I was and why I grew from engaging and experiencing this program with an open mind and awareness to become a better person. That's why I liked this course the most, because it helped me to change who I am.
What do you plan to do if released?
My plans to be released is to go to transition, finish the course that they got for me, move in with my girl, help her with her mom, because her mom dealing with dementia. You know, be a role model to my nieces and nephews, her son, help my mother out, whatever she needs to be helped with, you know, help out in the community and enjoy life.
What kind of guy would you say he is?
He's very quiet. We don't have any disciplinary issues out of him at all. He's very respectful. He has a good work ethic, according to his supervisor. I do want to mention that we provide opportunities for our inmates to do some community service and participate in some community service. And he has been a participant of those programs that we brought in. So I did want to mention that. But he's not a behavioral problem. Like I said, he stays to himself. He's, completed classes. Since he's been here, he's not been any issue whatsoever.
Thank you so much.
Mr. Papa?
Yeah, what would you, I'm looking back at the flooding the cell, lighting it on fire and all of that. What would you say was the biggest thing behind that caused you to do that?
Anger, temper, making bad decisions.
It wasn't that long ago.
4.5 years ago.
All right,
Good. Executive session, please.
We have a request in the second for executive session.
Lagoon?
Yes.
Tillis?
Yes.
Lala?
yeah.
It's executive session Tuesday at the board. Okie dokie. TCF Live, now in hour 3 on this fine Tuesday. Let's go back to Texas, but in our promise for 9 to 11% more, Judge Boyd. I give you Judge Boyd.
For the defense. All right, and are you Mr. Garcia?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke probation with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Are you the same Christopher Eugene Garcia who's placed on community supervision in 2021 CR 1825 for the offense of assault, bodily injury, family household on July 22nd, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
Right, state?
Yes, Judge. The state is proceeding on violations number 5. In Bexar County, Texas, the defendant, Christopher A. Garcia, defendant there, failed to report to the supervision officer as directed for the months of August and September 2021 in violation of condition number 5. Then in Bexar County, Texas, the defendant, Christopher A. Garcia, defendant there failed to report to the supervision officer as directed for the months of March and April 2022 in violation of condition number 5. Then we're proceeding, Judge, on the supplement as well, violation number 5. In Bexar County, Texas, the defendant, Christopher A. Garcia, defendant there failed to report to the supervision officer as directed for the months of May, June, July, August, September, October, November, and December 2022, violation of condition number 5. And lastly, Judge, condition number 5, in Bexar County, Texas, the defendant, Christopher J. Garcia, defendant there failed to report to the supervision officer as arrested for the month of January, February, March, April, May, and June 2023, violation of condition number 5. The state is recommending revocation, Your Honor.
Just 1 second. To those violations of 5, 5, 5, and 5, how do you plead? True or not true?
True.
And state, are you waiving the other violations? Any objections to the waivers?
No objection.
Did you understand by pleading true to 5, 5, 5, and 5, the court could find it true and sentence you up to 1 year in the Bexar County Jail?
Yes, Your Honor.
Knowing that, do you still wish to plead true?
True.
Yes?
Yes, Your Honor.
All right, the court will find 5, 5, 5, and 5 true. Is there a proposed agreement?
Judge, the state is recommending revocation in 1 year in Bexar County.
The
defense does not agree.
All right, what are you all requesting?
Judge, we are requesting that either he be continued or terminated unsuccessfully. And there are reasons why we're asking this.
Yes.
For the last, since 2022, he did have a hiccup
And since then, he was afraid to report. That is why he was scared to report. He just didn't do anything after that. Since then, he has no new crimes. For the last 4 years, he has managed to live in the same residence. He has also maintained the same job for the last 4 years. And what is going to keep him on the right path now is that his son was diagnosed in what year?
It's just been 2 years now.
For 2 years ago, diagnosed with, and I can't pronounce it, what is it?
Ewing sarcoma cancer.
And it is fatal. It is terminal. He was given 6 months. I'm sorry, the first he was given 2 years. He is on the second year now, and now he's given 6 months. He
Where's
has
the proof of this? Have you, counsel, have you?
I haven't had
seen
the
proof?
opportunity, no.
So I don't know if that's true or not, sir.
I came prepared with the phone number where you can reach.
Well, no, I can't call anyone.
If this makes a difference, to your honor, I would ask for a reset then so that I can get the proof from his family.
All right. Okay. I will give you a 2-week reset.
Thank you, Judge.
All right, Norma, recall this in 2 weeks.
Okie dokie, friends, let's go back to Louisiana and see what's going on with the board. They're coming back from session.
All right.
Thank you. The panel has resumed and without any objection. We have heard, Mr. DeMillion, from you, but is there anything else that you would like to say? I know you came prepared for this hearing. You had your statement. Is there anything that we did not allow you to say before we vote?
Really, I just was hoping, the board give me a consideration, give me a second chance.
Well, since you're a second class offender, this would be your third chance, but yes. Okay. Mr. DeMillion, having read over your case carefully, you had 3 other co-defendants who have all been released.
Yes,
You're
ma'am.
still incarcerated. You have, and I want to thank the staff there at David Wade for giving you the opportunity to take the classes because you have availed yourself. They did offer that, and it was a good thing for you. My vote today is going to be to grant you parole, to go to the parole project for a period of not less than 6 months. And during that time, I would like the parole project to make sure that they do a mental health evaluation, which is a common part of their programming. And that would be my vote today. Mr. Barra?
I'm looking at this case and I see that there's pretty much no victim opposition. 4 victims were unable to be located and talked to. 1 victim said no comment. Law enforcement has little comment, little opposition, and you have a low Tiger score. That's the risk score. So with those 3 things being said, I'm going to go ahead and concur with Ms. Ledoux parole project for 6 months with mental health evaluation during that time, and also take a look at his anger management because no telling if he might not need some extra evaluation follow-up.
Mr. Raymond, there's one thing I'd like to add to that. You said you were gonna, if released, you would move in with your friend. I don't think that's a good idea. We see a lot of people return. If you're gonna move in, whether you need to be married to it, don't you think?
Yes, sir.
You really don't need to be moving in with somebody, and I think if you love her that much, you ought to marry her. My vote's going to be to concur, and to the Louisiana Parole Project.
So today, based on a unanimous vote, you have been granted parole. You know, you will be on supervision until 2035, so make sure you follow the rules. That
Yes,
can,
ma'am. Thank you.
here, it's 9:49.
Approved? Well, there you have it, friends, an approval. Sometimes that happens. Okie dokie, let's go to Lake County, Ohio, but instead of Judge O'Donnell, this is Judge Collada, as I understand it. He's going to do a sentencing.
We are here today in the state of Ohio versus Jerry A. McElroy, case number 26CR000276. Defendant is present in open court today with his counsel, John Fatika. Your Honor, here today for sentencing. The defendant was last before Your Honor on April 28th of 2026, where he pled guilty by way of information to two separate and distinct counts of aggravated possession of drugs, felonies of the fifth degree, with forfeiture specifications. These counts do not merge. At that time, a pre-sentence report and drug and alcohol evaluation were ordered. It's the state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. There's no sentencing agreement. Thank you.
Mr. Patik, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do. Good morning, Your Honor. I've had an opportunity, as we said last week, to review the PSR as well as the drug and alcohol evaluation. We acknowledge that Mr. McElroy has an extensive criminal history prior to prison, but he had been doing some things well. He obtained his temporary driver's license, was attending some AA meetings. We submitted some letters on his behalf. He was working. His niece passed away. I think that put him in a little bit of a tailspin. And he was candid in the PSR that he does not have the tools. He did not have the tools to remain sober. I think he was very transparent about that. He's been at the jail 58 days, no incidents, which I emphasizing because if he was put in a treatment situation, I think he could be compliant. We appreciate the court referring him for a NeoCap evaluation. We ask you to consider that.
Thank you. Mr. McElroy, you have the right to address this court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
Sure, yes. I'm 60 years old. It's time for me to change.
Well, it's been time for you to change.
Yes, it's a long time ago. I do need the help. When I got out of prison this last time, I was doing so good. I was so proud of myself. And then my niece passed away, and I fell right back into the spot where I knew where I was comfortable at, to numb the pain. But I do need the help for the disease I have. That's alcohol and drugs. And I could appreciate it if I can get that help.
Right, thank you.
You're welcome.
Was there anything, is there anything else you wanted to say?
No, that's it.
Mr. Patik, anything else?
No, thank you, Your Honor.
Ms. Cutts for the state.
Thank you, Your Honor. This is a case that began as in essence, a traffic stop at a gas station. The defendant had methamphetamine on him. Initially, an amount was found in a pack of cigarettes. Once he was arrested and on his way to the jail, he was asked, if you bring any additional drugs into the jail, that could be different charges. He did indicate that he had more on him, and when he got to the jail, it was found in his pants. He made sure to provide it. It was over the bulk amount, 3.31 grams of methamphetamine from the second grouping in the pants. He was given the opportunity for an F5 through the information offer, but I just mentioned that for the seriousness factor. He does have a history of...
What do you mean for the seriousness factor?
So this is more serious than an F5 would normally be because it could have been an F3. So just that it was
Oh.
more amount of drug than a normal F5
Gotcha.
would be.
Gotcha.
As for recidivism factors, he does have a history of juvenile adjudications and criminal convictions. Those are obviously laid out in the pre-sentence report. I won't go through them individually. He does have a juvenile record that spans from 1983 to 1986. He had multiple probation violations, and he was sent to DYS. His adult history began in 1988. His first felony was in 89. His first prison was in 1992. His record consists of offenses of violence, property crimes, weapons, as well as drug and alcohol charges. Drug charges beginning in 1999. He does have 5 OVIs. His last conviction is from 2024, which was an aggravated possession of drugs found in the 3rd degree. He did go to prison on that case. He does have 7 prior prison numbers on approximately 15 to 16 cases. He was last released December 1st of 2025. In this case, he did violate his bond when he tested positive for methamphetamine and amphetamines on April 22nd of 2026, so his bond was revoked at that time. So he hasn't responded favorably to previous sanctions. He does acknowledge his drug and alcohol issues. He has had some treatment ordered in the past. If my understanding is correct, his last might have been in 2016. So prison is clearly consistent. The question is if this court is willing to give him an opportunity or a chance at treatment. If the court is inclined to do so, the state would recommend basically the full gamut to give him the most tools and most time to stay sober with jail treatment program, NeoCap, Lake House or Concord Pines, and then sober living, and follow the recommendations from each of those activities or organizations. Obviously, we would ask that he not use any drugs or alcohol, that he submit to periodic screens, those need to come back negative, that he be involved in 12-step programming weekly with a sponsor and a home group. They have 1 doctor, 1 dentist, 1 pharmacy, sign releases for probation. If he is prescribed any medications, that he take them only as prescribed. That he get a mental health evaluation, follow any recommendations. When he's able to engage in full-time work or school, work towards obtaining a GED. There is a forfeiture in this case that involves the methamphetamine, cigarette pack, plastic, and packaging. And that if he is given the opportunity, just that he is made aware that if he were to violate, he could be looking at prison again. That'd be the state's thoughts at this time.
Thank you. This court considered the pre-sentence report investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offenses, the nature of the offenses. I've considered multiple letters that I've received from, on behalf of the defendant, I should say. I've considered what's been said here today by the defendant, his lawyer, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. Also consider the factors in 29, 29, 12. Factors indicating the conduct is more or less serious. Again, the amount involved is alluded to by the prosecutor is more than what we normally see for an F5. It would be a more serious offense, but it's an F5, so it's more than that. That makes it more serious. Nothing makes it less serious. As for recidivism factors, obviously this is where the problem lies. There's a lengthy history of juvenile delinquency adjudications and convictions as an adult. It's over 40 years. The defendant has served multiple prison terms. He has failed to comply in the past with previously imposed sanctions ordered by multiple courts. Violated the bond in this case here by using drugs while on bond. Obviously, the drug abuse problem relates to the offense, and it's not that he doesn't recognize it, he acknowledges it, but he hasn't done anything to address it. These are all factors indicating recidivism is more likely. There's nothing indicating it's less likely. Under 2913B1, the defendant previously served a prison term. Prison's certainly consistent with the purposes and principles of sentencing, and certainly it would be an easy and simple decision for the court to impose a prison term. I've done it before. Other judges have done it before. When you look at the history, it seems like it's a no-brainer, quite frankly. But Mr. McElroy, I'll give you one chance. I don't know. We've done prison multiple times, and we keep coming back here. I don't know if this will work or not, but you're only going to get one chance. And you need to make sure you understand that. There's not going to be any excuses. At this time, you say your niece passed away and it really bothered you, and I'm not saying it didn't or that you're making that up, but you're not going to be able to deal with it by using drugs. Hopefully, what we're going to do here is going to give you resources to learn how to deal with that. But there's not going to be excuses, no matter how tragic something may occur in your life. It's not going to be an excuse. You're going to get one shot. And if you're successful, then you won't be back here. If you're not successful, you're going to come back, you're going to get the maximum sentence. And when you come back in the future, you're just going to prison. There's going to be nothing else we're even going to consider. And you're going to be in front of me if you're in Lake County. You understand that?
Yes, sir.
All right. I'll find you're amenable to an available community control sanction, but I'm going to give you what we have to offer here. It's not going to be fair to you not to do that, because then you're not going to, with your history, you're not going to succeed. So I'm going to put you on community control sanctions for a period of 30 months. I'm going to order that you serve 110 days in jail. You have credit for 58 you've already served. I'm going to order that you immediately enter and successfully complete the jail treatment program. Upon completion of that, you will be released as soon as a bed's available at NeoCap, and there's not much of a wait right now at all at NeoCap. So as soon as a bed's available after you successfully complete JTP, you'll be released from the jail. You are to enter and successfully complete the programming at NeoCap. Follow all their aftercare recommendations. Upon completion of NeoCap, I'm going to order, and you're most likely not going to have to do this. Well, first I'm going to order that you return to jail for 30 days for the transitional day reporting program. Again, I doubt you're going to have to do this, but it's a program that helps people make the transition from being locked up to being on their own. There's many people that when they've been in custody for a while and they're released, they have nowhere to go. They have no housing, no work, and this is a nice program that helps them make that adjustment. But if that's not an issue for you, then you won't have to do it. But I put it in place for everybody that goes to NeoCap because it's a good program, so I'm putting it in place here. I am going to order that when NeoCap is over, that you reside in a sober living residence for at least 6 months. So that should go from NeoCap to there, and that should be set up beforehand. If it's not, then the TDR program will be that stopgap, but that should be all set up for when you get out, you go right to that. Further conditions, if you want to stay there longer, you can, but you have to stay for at least 6 months. Then, further conditions are going to be the regular conditions. You're not to use any drugs or alcohol, no marijuana, nothing. You must submit random urine screens. They have to be negative. A positive screen will be a violation. You can't tamper with or screw around with your urine samples at all. You're to attend at least 3 AA meetings a week and have a sponsor. You're to obtain and maintain full-time employment once you get out, you're at sober living, that's what you'll be doing then. money to obtain mental health counseling, and restart all of your mental health medications and follow all recommendations. So to take all medications as prescribed. So when you get mental health counseling and restart your mental health medications. You pay your court costs and supervision fees. I'll order the forfeiture of the contraband that was seized. I will release your bond. I'm not forfeiting your bond. Was it even posted? Was there something? Yeah, bond, whatever bond there is released. Josie, are there any other conditions you can think of that we should consider here?
Nothing further, Your Honor. You've covered every basis.
I'm sorry?
You've covered every basis that we would have.
So, Mr. McElroy, you understand these conditions? I mean, the next several months are going to be focusing on getting you better and learning what you need to learn, and it's a little bit of time. You're not just not going to be quick, but you got a lot of issues that need to be addressed, and you got to put forth the effort here and make this work.
And I appreciate it.
All right. Well, once you do it, once this is done, then you just got to basically work, remain sober, report to your probation officer. So we're giving you that chance. Do you understand all the conditions?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while on probation, a motion to terminate your community control will be filed. If it's found that you violated, I could extend you up to 5 years, technically. I can impose more restrictive sanctions against you, or I can and will terminate your probation and send you to prison. If I did that, it would be 12 months on each count, consecutive for 2 years in prison, which could also be consecutive to any other prison sentence you may be serving at that time for something else, if something else occurs, or that you're being sentenced to at that time for something new. You understand that?
Yes, sir.
All right. Ms. Cutts, anything else for the record?
Your Honor, just to clarify, the community control is concurrent on each count?
Yes.
And then if he completes JTP and NeoCap before his jail sentence is up, the remaining would be?
Well, he wouldn't complete NeoCap before that.
Sorry. If he completed jail treatment program and they were ready to send him to NeoCap?
The balance of the jail sentence is
Be
vacated.
suspended. Okay,
Yeah.
thank you.
Yeah. Mr. Fatigue, anything else?
No, thank you very much.
Okie dokie, friends. TCF Live, Hour 3. Hope you're all enjoying your day so far. I know I am. Let's go back up to Michigan. We're going to spend a few minutes with Judge McNally. If you look to his left, I think there is solid evidence that it is Take Your Granddaughter to Work Day in the 33rd.
She's paid the B file, by the way. How you doing, ma'am? Your name?
Denise Work.
All right, so we're going to adjourn this pretrial. We're going to set it for July. Do I have a judge on July 7th, Lisa?
Just doing PCCs with Judge Hessen.
What's that? Just doing PCCs?
Yeah,
So-
PCCs only.
So we're going to do it at July the 14th, maybe would be my next date.
Yes, July
She
14th
wants
at 8:30.
She wants 3 weeks. So I'm going to give you till July 14th at 8:30. Okay? Okay?
So what do I even go to the Secretary of State and?
I don't know. It says adjourn for 4 weeks for defendant to get license back. I don't know the status of your license. And then you make sure you try to go, don't procrastinate so we can get it done with on July the 14th.
You say my date come back July 14th at 8:30.
Correct. Okay? Let me just check something here. When's the last time you had a valid license? When's the last time you had a valid license? That's what I thought.
It's been a long time.
We'll go get this taken care of. It doesn't look like it's gonna be that big of an issue, but you gotta go take care of it, okay? But I'll get your notice. Thank you.
Okay, thank you.
All right. I'm ready for Henry Franklin Joseph Lent, if you are, Mr.
I am, sir.
Mr. Graziani. This is 26T725-297, and I need to have the victim, know if the victim is here on this case, and that's Catherine Berlinski.
No, not on Zoom.
All right. Is anybody by that name in the courtroom right now? Your name, sir?
Henry Rhodes. Sean, what's here on behalf of Henry, we have no additions, deletions, or corrections, but we do have a statement to make.
Okay.
And we're hoping you adopt the recommendation.
All right. What would you like to say?
Judge, even though this is, major hiccup, a very stupid mistake that this gentleman made, he's a very decent individual. Even though he's a well-educated gentleman, like many of us, he's immature for his age, and he had a horrible lapse of judgment. With all due respect to the system, Judge, this young man's already suffered significantly. He's been terminated from his employment since last July. Because of this incident, Judge, he's unemployable, and it appears for the next 5 years, he'll essentially be unemployable from from the employment that he was involved with, Judge.
You went to the University of Michigan
For undergraduate, yes.
and you were going to be a physician?
He is a physician, Judge. And with all due respect, Judge, like I said, it was a horrible lapse of judgment. Mr. Lett and I have had many discussions, and a lot of young people these days are casual in their conversations and in the dissemination of information. Many times, the new information age is something that is highly destructive, as we've witnessed. The AI age is one that can benefit society tremendously, but it's also one that can destroy persons, particularly in this situation. I believe that this gentleman next to me will be able to come back, but it's going to be a heck of a long time before he comes back. He is extremely remorseful. He's had notes that he sent to me, and he's just one of the most decent human beings that I've ever met. Again, this is stupid what was done, but like I said, we're living in a day and age where dissemination.
Why are you doing this to yourself? I mean, I'm looking at a kid here. I remember talking about this. I didn't realize you had this much going for you.
He's a brilliant.
You went to Cranbrook, you went to the University of Michigan, physician residency program. And then you do something silly like this.
Yes. Judge, if I may interject,
were you under the influence of alcohol or drugs at the time you did this?
No, not at all, sir.
I didn't have any evidence of that. Go ahead.
Judge, in this day and age, in this wonderful, and I'm saying it sarcastically, AI age, a lot of folks tend to be very casual about the dissemination of information, and I feel that's essentially what happened over here. There certainly wasn't any malicious intent at that time, and again, Mr. Lett is extremely remorseful. It's cost him his livelihood, and I've advised.
So Corwell found out about this and they terminated you?
I finished my residency program and I had another job lined up.
Where?
At the same hospital, Corwell Churchill.
Okay.
And then when they ran a background check, they found this charge was pending. So they withdrew their offer. May I add, Judge, since that period of time, he's applied at numerous places, countless places, and has been unsuccessful. We discussed his future and that he's going to have to take a sidestep. And he's going to have to, he'll still be able to practice medicine, but it's going to.
Yeah, but what's he got going on in the row? He also had a B&E without owner's permission.
Judge,
and he's got a picture out in a week, for a
Judge,
few days.
With all due respect, the matter is blown out of portion without getting into tremendous details. This was a situation in which this gentleman tried to help out that individual who was having a mental breakdown, and he had a friendship with that person and knocked on the door responsibly. And again, no malicious intent. And in fact, that alleged victim did not even want to pursue charges. It is a family member of the alleged victim who wishes to pursue charges. Nothing happened there. Nothing was stolen, Judge. It was just simply to try to help out that individual, Judge. That's all that went on in Monroe County.
One thing I've always said, do you want to say anything else?
Are you talking to me, Judge?
No, I'm talking to him.
I suppose I should say that I understand clearly now that what I did was wrong. And it wasn't just wrong, it was also directly harmful to somebody that I considered to be a friend and would never have wished to hurt. I don't have a good explanation for how my judgment would have been. So for whatever that would have been, that was acceptable. But I apologize to Mr. Berlinski for what I did and became distressed that I caused her. I wish I could take that back.
Judge, in this, you had numerous people who've done some very, very stupid things in this courtroom. There was one individual years ago who did stupid things, and this individual is in his 60s now. And that individual never received help. Mr. Lent is proceeding extensive help, and he's going to be even more aggressive. And
help where?
it would through therapy, through psychiatric help, through medications, Judge. Mr. Lent realizes that this can't happen again. Otherwise, he'll be permanently
Well, what is he undergoing at Rochester? I wrote down a psychological evaluation and treatment if recommended. Are you seeking, and have you been in mental health treatment?
Yes, I've been seeing a counselor for about the past 2 years.
Yeah.
Rochester Area Counseling Services.
He's also seen a psychiatrist, Judge, and he's taken it very seriously, which he should.
I mean, you must be a bright guy. You know that? You must be a bright guy. I mean, you don't get through Cranbrook and University of Michigan and become a physician unless you're bright and work hard, but you got to use your head. I mean, you just got to use your head.
Yes, I understand.
It's nothing worse in my view than going to your grave at some point, whether we saying I underachieved. I just can't even imagine that. I'm not going to adopt this recommendation. I think he's remorseful. I think what he did was ridiculous. I told him that. I raised my voice with him at the time of the pretrial. But I still have a heart. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Continue your mental health treatment.
Yes.
Is that all at Rochester area counseling?
Yes.
Continue that. I'm not going to pile on with the rest of this, and I have no evidence that alcohol was involved or drugs were involved at this. I know he had a drunk driving 4 years ago, but I'm not going to order that. No contact with Catherine Belinsky at all. You cannot write, phone, see, text, email her, or communicate with her, or have anybody else do any of those things for you or on your behalf. You're going to serve 48 hours of community service. Could have been a lot worse. I do not like this kind of thing. We don't embarrass one another. 48 hours of community service by August the 10th. 48 hours of community service by August the 10th. Fines are 100, costs are 200, 75 victims' rights fee, $50 justice assessment, 4.25. Probation fees are 240 for 665. Screening fee is 60, 725. Attorney fees of 40, 765. If you violate your probation, could be revoked. You could be incarcerated for 90 days. I don't know why. I'm going out of my way here because I truly believe you're remorseful. But you got to make sure this is the last of your mistakes here.
Yes, sir.
We can't afford to make mistakes. We need to make mistakes, but not mistakes like you're making.
Chuck, I explained to him that a man that appeared in front of you a number of years ago was always doing some very, very stupid things, and now he's in his 60s and he is in the Michigan State prison system. Minimum security, but nonetheless, because of the stupidity and failure to address these issues, he's messed up.
All right, can you pay this now or do you need time? If you need time, I have no problem.
Judge, I would request time.
How much time?
Can you do it 2 months?
Yes.
I'll just make it September 1st. You pay it when you can. I just sense you're remorseful. I'm taking a chance now. Don't let me down.
I appreciate it.
But if you violate, you're gonna get 90 days. Do we understand that?
Perfect.
Good. Have a good day. Good luck to you. You'll meet with probation.
So unfortunately, yet another example there of somebody with everything going for them who's trying desperately to throw it all away. Hope they get their act together. Anywho, a few more minutes left here at TCF Live. Barbara, thank you for the $5. Dan, thanks for being the best host on YouTube. Don't know that I'm the best, Barbara, but doggone it, I try to be just a little bit better every day, because that is the best that I or anybody can really do. So thank you again for the $5. Let's go back to Texas. Judge West, probably finish our day with her.
Yes, ma'am.
And this, we've got 2 cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may, he has a new DWI third. I've spoken with this officer, Ms. Kane, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, go with the new case outstanding. Obviously, the new case I will not dismiss, and obviously the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
Oh, that's the agreement with the defense, yeah.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks I've.
Well, that's going to be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's going to take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
Agreement. No agreement. So it's just what you guys obviously would recommend. Sure. So do we want to go through the motion today then?
We can.
Or
I'd rather have the which one would expedite the
A plea would, because I could push it through without the lab, but if, in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
All right. We'll just
Let's do
reset. I'll
that.
just do a normal reset.
Thank
Y'all
you.
See if y'all can get that taken care of.
Yes, ma'am.
All right, and go back with the bailiff. Darrell Lee, oh, she's not over there. Darrell Lee is being dismissed, so he can be taken back. Just, I'm signing that now. Let's take care of Mr. Parker. Can we take care of Isis Martin?
Okay.
Isis Martin.
Need my files, got you.
Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give you more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the plea?
Yes, ma'am. Yes,
I'm sorry?
She has no criminal history. This is only arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go to straight there, you also run the risk of me not accepting the plea agreement. Do you understand that as well?
Yes, ma'am.
And then also a condition of your bond is that you have absolutely no contact or communication with Harmony Bodner. That obviously means in person, but it means any other way as well. So you can't send messages through other people. You can't send messages on your phone, by text or Snapchat or whatever else exists out there. Do you understand?
Yes, ma'am.
Do y'all live anywhere close to each other?
No.
Okay, so there's no reason for you to have any contact with her. So you need to show me between now and when you come back that you can do everything you're supposed to, so I don't have any issues with putting you on that probation, okay?
Yes, ma'am.
All right, we'll see you back at sentencing.
Okie dokie, friends, that's going to do it for today. I hope you all enjoyed your time here on TCF Live. I enjoyed bringing it to you. So much so that we'll do it again tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members. But wait, you don't have to wait until tomorrow. Come back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We're going to talk about the idea of whether or not a judge should be able to see the same defendant multiple times. Would that create kind of a bias or anything? So we'll hash that out on Sidebar tonight. The wisdom I choose to leave you with today comes to us from the book of Matthew. Therefore, do not be anxious about tomorrow, for tomorrow will be anxious for itself. Let the day's own trouble be sufficient for the day. I think those are good words. All right, my friends, I will see you soon. Take care. God bless.